everyone, my name is Sherine and I'm a family law lawyer here at AP Lawyers, and today I wanted to talk to you about the topic of parallel parenting. For those of you that are unaware, parallel parenting is really a form of joint custody, and custody is the ability to make fundamental and important decisions affecting the welfare, care, and upbringing of your child or children. I would say the key difference between a joint parenting regime and a parallel parenting regime really lies in the decision-making aspect. In a joint parenting arrangement, both parties together have to come to an agreement prior to that decision being enforceable, whereas in a parallel parenting arrangement, you can actually split important decisions in important key areas in a child's life, and that party can have final say over those areas, and the other party can have final say over those other areas. So for today's illustration purposes, I'll use 4 broad categories of important areas in a child's life, and that's education, religion, healthcare, and extracurricular activities. So for example, one party can have final say over religion and education, and the other party can have final say over healthcare and extracurricular activities. So it kind of helps both parties be equally involved, and really parallel parenting is made appropriate for parties where they have highly contentious matters and it's not appropriate for them to have a joint parenting arrangement because they're very unlikely to come to a decision together, and through means of kind of their situation, whether through abuse, whatever it may be, they just simply don't get along enough to make those joint decisions, and where it's really difficult to make those joint decisions. Now, it doesn't eliminate that both parties have to come to some sort of consultation process together prior to the decision being made, but it allows one party in that designated area to come to a final decision in that area if in the event of a disagreement. Whereas in a joint parenting arrangement, in the event of a disagreement, you're really left with the recourse of either negotiations through counsel, participating in alternative forms of dispute resolution, which is mediation or arbitration, even doing parenting coordination, ultimately to litigate the issue. So it's definitely a lot more productive for parties who are unable to kind of make those joint decisions together, and not appropriately so given the party's history. So it allows both parties to be equally involved without relinquishing any of their custodial rights. It's an added benefit because it reduces a lot of stress for the parties, because you can limit the amount of communication, and it can be even through only electronic means. And it definitely allows parties to still be equally involved. I think that's the biggest benefit to really both parents. So definitely, if you and your spouse are having issues kind of coming to those custodial decisions, who makes them, maybe consider the possibility of having a parallel parenting arrangement if you're both able to act in the best interest of the child and a joint parenting arrangement is not possible. So thank you so much for watching, and I hope you have a great day.